Dear students, this class we are going to specifically look into two categories of intellectual property law, that is patent and trademarks. And specifically we are going to look into the philosophy, what is this category of the intellectual property, and if you look into the patents, what is the patent and what is the patentability criteria mentioned in the TRIPS agreement, the minimum terms of protection, and talks about compulsory licensing, non patentable subject matter and trademark. And here you can see a picture, and they all saying that all I asked was, can I patent my copyrighted trademark? So, this is a common confusion. What can be patented, what can be copyrighted, what can be trademark, what is the difference between this? So, if you are finding no problem with this statement, it means that you do not know the intellectual property, you require an intellectual property law class. So, you have to understand more about intellectual property and different categories of intellectual property. So, then you will see that where I should go. So, I have an innovation, what are the type of protection which I should adopt, whether I will go for copyright registration or whether I will go for patent registration or I will go for trademark registration. So, this confusion also always exists for the inventor or the innovator. So, we must know the criteria to fix all these categories of intellectual property law separately. So, as we already said that the earlier class, that it is not the first time the intellectual property came to the TRIPS agreement. Intellectual property is protected from time immemorial period, and you can see some of the inventions in the 15th century, 1421 in Florence. So, he was given a patent and 3-year monopoly. So, it is the patent was granted for on manufacture of a barge with a hoisting gear used to transport marble. So, we saw the many countries like UK Parliament, followed by US, followed by other countries, whether it is Japan and other countries, granted patents. And the first recorded patent granted to John of Union by King Henry VI. So, this was in 1449. So, you can see the coincidence, and he was the first patent was granted for 20 years for glass making process, stained glass, which was unknown in England, not heard for, and he made a stained glass window in Eton College. So, the king has granted a patent for 20 years. Under the present TRIPS agreement is also, it is 20 years term is the minimum term of protection which is provided. So, 1449 a 20-year monopoly is granted, and in the 21st century also is granted 20 years monopoly. So, in return, so the king has asked him to teach this particular process to the Englishman. So, after 20 years, so the Englishman can use this particular technology for making stained glasses. So, in 1449 the first patent was granted in England. If you look into the US, the first patent was granted in 1790, and this patent was granted for improvement in making potash. So, you can see that this making in potash, and potash, what is potash, you know that it is a chemical or a fertilizer, basically fertilizer, and pearl ash, potash and pearl ash by a new apparatus and process, and still potash is used as agriculture, is used as a fertilizer mostly for the agricultural purposes. So, you can see on the right side the patent certificate, and which was signed by the President of the United States at that point of time, George Washington, and the Secretary of the State, Thomas Jefferson, Attorney General. It is signed by all these people, and only 2 other patents are granted on that particular year. So, you know that it is. So, it is what I want to say is the granting of patent is not new. So, it was a process which is started in England and then to the US and other countries. So, now you see the panoramic view of the innovations from 1776 to the projections from 2025. We are in 2023, and you can see around is around 9 million patents or innovations. In 1776, and also here you can see that starting with this history with 1776, it is reached to the level of millions. So, and it is going to be 10 million to 11 million in the coming years. So, it is crossing 10 million innovations. So, you can see these innovations or famous or path breaking innovations like telegraph in 1840, and you can see flying machines in 1906. You can see transistors, personal computer which entirely changed the world in the invention in 1979. The treatment, for example, the heart treatment with the invention of stent, medical stent, and Bluetooth devices are very recent in origin, 2003. Mobile networks, mobiles, the telecommunication technologies, thousands and millions of technologies which you can find from this particular period. So, you can see that 1800 to 2025. So, this gives a panoramic view of innovations. So, innovation going in a very fast mode from 1950s. If I would say that in 1995 it was 5 million, and within a period of 20 years or 25 years, or it is going to be 28 years, it is doubled 10 million. That means innovations are happening in the world very quickly, and we will quickly see some of the very simple innovations. Paper clip, gem clip we call it. The paper clip was patented in 1899. It was a patented product. It was an innovation. Still we use it, and we did not know that it was patented product once upon a time. And also the first patent granted in India. So, you ask anybody and most of the people does not know about it. So, it was happened in 1856 to definitely to an English man, an English engineer, George Alfred D. Penny. So, he filed the patent application, and he was staying in Kolkata, and he was granted the first patent in India, and this patent was granted for his invention, an efficient panga pulling machine. So, to understand this, what is this panga pulling machine, you must understand that there was no fan, there was no panga means fan, and fan was not there at that point of time, and this it was artificially So, you can see that this is the left side and right side pictures, which shows that how it was put, it was the fans were made. So, this was the old fan, and some people were manually pulling this equipment, so that there will be sufficient the comfort which is given to the guest. So, the guest will feel comfortable by pulling these by manually by human beings. So, he made a machine automatically pulling machine for this instead of manually pulling, a machine was formed, a panga pulling machine. Now, you can see the beautiful fans. So, how it is transformed, this panga pulling machine transformed into fans. Now, all these fans are also, the modern fans are also is patented. So, the most important innovator, Thomas Alva Edison. So, he was known as the genius, and so you can see that he have thousands of innovations and thousands of inventions. So, definitely Thomas Alva Edison was a school dropout, but he had 2332 patents, all famous patents. So, whether it is a phonograph or motion pictures camera, and then electrical bulb, that is one of the the most important. So, you think that now you use the stencil pens in the laptops, but you can see that the US patent was granted in many years back. So, now you can look like tattoo machine at that point of time. So, the tattoo machines were made in the US many years back by it was patented by Thomas Alva Edison at that point of time. So, you tattoo now itself, but it is the machine was patented many years back. And so, as I told you, you can see there is a variety of patents which you can find, where it is electrical power on phonograph, telegraph, battery, telephone. So, he has patented n number of patents in various areas. So, you can see even compass. So, it is very interesting to know that how the compass is made at that point of time, and what is the modern compass. Everybody is know about the modern compass, but how the compass is made at that point of time. This was patented at that point of time. So, we can see that the patents, the owner of the patent gets exclusive right for a period of limited time, now 20 years, to use, to sell it, to license that particular invention. And also it is known as the negative right, because the patent owner gets exclusive right for a period of time and excluding all others for manufacturing, using, copying and selling and the device or the process. So, it is a negative right which is implemented by the patent owner. So, we know that we have a misconception that once it is patented, it is worldwide validity. The answer is no. A patent have only territorial validity. If it is registered in India, it is valid only in India. If it is registered in the US, it is only valid in the US. But multiple countries you can register at a time through the PCT regime, that is the Patent Cooperation Treaty of WIPO. So, around 60 countries are covered under this particular treaty. So, you have to file only one application with these particular countries mentioned, but patent is highly territorial in nature. It is valid only in your country, not in other countries. So, you have to separately take protection in that particular jurisdictions. So, this is considered to be one of the drawback of the TRIPS regime. So, you have to go to each and every country and file patent applications. And then patent, as we already said, that it is a statutory right given to the inventor. It is a statutory right, and this right is for a limited period of time, and it is restricted patent to 20 years. And this is granted the same philosophy which is granted by the king. So, disclosure to the public, it is not only to the patent office, disclosure to the public, and it is a territorial right which I already said, and it is a negative right. So, preventing others from doing or copying, and also the patent right completely prevents third parties from making, using, offering for sale, licensing, distributing, importing. So, you require the patent owners written consent for doing all these activities during the protection time, that is for 20 years time. So, Article 21J of the Indian Patent Act clearly says what is an invention. Only invention can be patented in India, not discoveries. So, what it says? Invention means a new product or process involving an inventive step and capable of industrial application. So, any invention means it can be a new product or process. So, in India there are process patents as well as product patent. So, registration can be made for processes as well as products, which comply with two criteria. One is the inventive step and second is industrial application. So, this definition is completely in consonance with the TRIPS agreement. So, if we look into the general criteria, you can see that invention must be new, novel. So, the novelty criteria is very clear, it is not known to the public prior to claim by inventor. So, the novelty criteria is very clear. So, what is this inventive step? Inventive step, so it is not obvious to a person with ordinary skill in the art. So, that means a skilled person in that particular area should not say that this is already existing. So, he should pass the inventive step. Then the last criteria is industrial application. So, it must be useful. So, the mere ideas cannot be patented. So, purely intellectual or aesthetic one cannot be patented. It must have an industrial application, then only it can be patented. So, we already said that if it is already published, so we used to say that either you publish or perish, but in the case of patents it is other way around, you publish and perish. So, it should not be published earlier. Prior public knowledge or public use is a barrier for filing patents. So, it should not be claimed by anybody earlier. It is not known to the public, it is not published anywhere else. So, even though it is a 1 year period you can claim, but so the general criteria is very clear with regard to what you mean by new. So, inventive step, the criteria is also very clear, a technical advancement, a technical advancement from the existing knowledge. So, section 3D is a controversial provision in the Indian patent law, whether incremental innovations are patentable. The famous case, so the Madras High Court and the Supreme Court very clearly said that this is not, incremental innovations are non patentable in India. So, economic significance, another criteria. So, and the invention should not be obvious to a person, those who are skilled in the art. So, inventive step also, what are the criteria of inventive step is also very clear. So, for example, some of these very interesting questions come. Can you patent a food recipe? Can you patent a food recipe? So, the answer is yes, food recipe can be patented, but subject to certain conditions. What are these conditions? These are the same conditions, that is the novelty, non-obviousness and industrial application. So, it is interesting to see what is a novelty with regard to a food. The recipe needs to have an element of newness. So, should not be an extension of the older method. Non-obviousness, So, mixing admixture is a disqualification for patenting. So, mixing raw food materials cannot produce a patentable subject matter. Industrial application, a recipe should be useful for humans or animals or industrial level. So, food also can be patented subject to the same criteria. So, patentable subject matter is mentioned in the TRIPS agreement. So, any article, apparatus or its components. So, it can be living, non-living products, pharmaceutical product and any substances. But microorganisms, yes, there is certain reservations for India. So, genetically modified organisms is patentable in India and already existing microorganisms. So, the famous judgment. So, Ananda Mohan Chakrabarti got a patent in the US for a microorganism, but in India it is not patentable. So, the famous case is not applicable in India. Any composition of matter pharmaceutical products, any composition of matter or pharmaceutical products is non patentable. Process, so biological process, so other than essential biological process is patentable. So, patentability criteria is mentioned under article 27. So, article 27 very clearly says any field, all fields of technology. So, again the three criteria: inventive step and are capable of new involve an inventive step and are capable of industrial application, three criteria. So, these three criteria are applicable under article 27 as well. So, and 27(2) gives exceptions, what is not patentable. So, the patent can be rejected on the ground of public order or morality. Public order or morality is not defined. Public order or morality is not defined. It will differ from country to country and place to place. Public order or republic. So, it is given to the every country to determine what is against the public order or morality. Protect human, animal or plant life or health. Avoid serious prejudice to the environment. Diagnostic, therapeutic, surgical methods for treatment of human or animals. So, the methods for treating human beings or animals are non patentable. Then plants and animals, plants or animals are non patentable. Microorganisms, other than microorganisms. So, microorganisms are in most of the countries it is patentable. Essentially biological process for the production of plants or animals, but at the same time non biological and microbiological process. So, there is a lot of controversy with regard to forming animals by using the biotechnological methods. The Dolly case is very important, Dolly case is very famous. So, what is patentable and what is non patentable? The subject matter criteria and exceptions are mentioned under 27. So, if we come to India, so you can see that. So, the applications numbers are going up, but it is not going up like for example, it is a period of almost 6 years data, which clearly shows that there is no much progress in the number of applications. It is 40 to 50,000 and again it is dropping to 42,000. So, if you look into 2016 and 2022, it is almost there is no much variations in the number of applications, but the patent office has the grant of patent is increasing day by day. So, the number is increasing. So, the working of the patent offices are revamped by the government at this point of time, and probably the grant maybe is very quick in the recent times. So, the number of grants are increasing and it is reached to almost 21 and 22, it is almost 30,000, and I am very sure that 2023 it will be more, because if you take 2019, 20 or 21, it is affected by the pandemic, but 2023 it is not affected. So, the number may go up. So, the patent statistics India is not very encouraging. The number of applications filing is not very encouraging. And if you look into the filings in India, so in India, which are those companies or institutions filing patents in a single year, you can see some of the institutions. So, for a period of this same period from 2016 to 22, the data says that it is CSIR, the single government of India institution, is the number 1. Then 2, the second is also a government of India institution, that is the public limited company, that is Bharat Heavy Electricals. Then third only you can see a private company, that is TCS or TVS Motors, Tata Steel, or Tata Motors, Wipro, ITC, Mahindra and Mahindra, then L&T, Maruti Suzuki. So, we can see the trend is very clear. The private companies are filing very, so for example 6 years average, you can see that around less than 200 patents per year. So, the number of patents filed by the Indian companies are also not very high per year. So, and these are the company and public institutions, some of the public institutions are going up with the speed, and foreign companies, if you look into some of the foreign companies are filing India as our largest market of telecommunication, for example telecommunication equipments. So, Qualcomm is there, and another technologies in the telecommunication, Samsung and Huawei, Philips, Ericsson, Microsoft, Bosch. So, you can see these all multinational companies are there in India, because India is a huge market specifically for telecommunication and industries and other industries, and the ICT sector, I would say that. So, these are the companies which is filing in India for the last many years. And then comes the most important provision in the TRIPS agreement is compulsory licensing provision, but TRIPS has never used the terminology compulsory licensing. So, the TRIPS has used without consent. So, when it is happening, because most of the companies, those who went on negotiations with other companies for patent licensing. So, usually it is happened voluntary licenses. Once the voluntary licenses are not successful and the companies are reluctant to license, and also subject to certain conditions, the patent offices can go ahead with patenting compulsory licensing of the patents which are registered in their respective jurisdictions, definitely subject to certain common grounds, again subject to adequate remuneration. So, there is a lot of controversy. For example, India have made a compulsory licensing of only one medicine, and it is criticized by most of the countries and most of the multinational corporations, and it will be very difficult for any developing country to implement such decisions because of far reaching trade consequences and other consequences. So, the term of protection is very clearly mentioned now. The patent term is only 20 years and counted from the filing date. So, this is uniform among 164 member countries in the world. So, with regard to patents, if you can say that the patent the patent provisions which put the basic minimum criteria of protection under the TRIPS agreement, and also the patentability criteria is also mentioned, exemptions are also made, and the provisions for compulsory licensing are also made in the TRIPS agreement. Let us quickly come to the trademark agreement. So, trademark provisions are known to every country in the world, and we can see the trademarks identified particular business establishments, and registered trademarks and non registered trademarks which we can see. So, what is actually a trademark? The WIPO says a trademark is a unique way of identifying a product or service, to distinguish it from its competitors. It is very clear, and it is not necessary to register, but registration provides exclusive right. So, you can license it if you register it, or you can sell it if it is registered. So, there is more protection to a registered trademark. So, the next question is, what can be patented, what can be trademarked? So, the trademark can comprise of letters, numbers, words, colors, a phrase, and sound. Now, there is sound mark, smell mark, new categories, logo, shape, picture, this aspect of packaging or any combination of it. So, the trademark contains a complex set of individual components, and it must be to describe the goods or services. So, the generic terms, name of a place or a particular area, it will be very difficult to register. So, a product related to a particular region is registered in the geographic indications. So, Mumbai cannot be registered as a trademark. So, whether it is the electric or it is a plumbing cannot be registered as a trademark. And also trademark, and also we can find different categories: service mark, trade name. So, here you can see the distinctive symbols, logos to distinguish that particular good or services. At the same time, trade name of an enterprise, for example, Tata or Reliance, which comes to the consumer's mind. So, it is nothing to do with quality. So, trademark is nothing to do with the quality, and trademark is basically related to reputation. It is linked to reputation. It may be linked to the expectation of quality, maybe, but this is nothing to do with quality. It is linked with the reputation of a particular service or a particular company or a particular product. And also we can see the well known marks as well. Well known marks, collective mark. So, association of people, those who provide collective mark. Then there is a certification mark, standard of quality, which includes the certification mark. For example, the ISI mark, and presently earlier it was ISI mark in India, now it was the BSI marks, Bureau of Indian Standards, BIS marks. UG mark for agriculture products, hallmark for gold. So, you can see different certification marks. So, it may leads to quality, ingredients, and even geographical origin. Specifically, I said that now the protection is under Geographical Indications Act. And some of the forms of trademark. So, it can be visual, videos, or words or letters, numerals, devices, drawings, symbols, 2D representations, combination of 2D or more color combinations, 3D signs, shapes, packaging, sounds, musical notes, and smell mark. This can come under the trademark as well. And the criteria is very simple. One is distinctiveness, then inherent, acquired by usage, non-deceptible, not contrary to public order or morality, and also definitely these are some of the the criteria of trademark protection. And you can quickly see that some of the cases, in India there are number of cases, and everybody knows that what the Sony denotes. So, Sony company cannot prevent others from putting Sony. Even the Sony is a very popular name in India for people. So, Sony, but when it comes to a trademark, and it is to a particular company in electronics, but putting the same name to other areas are not prohibited. So, it is not a general name, it is a registered trademark. So, but in some of the cases, so you can see here one Indian manufacturer of undergarment comes to this particular advertisement, VIP Benz, in this shown in the picture. So, you can see the and the name is Benz. So, the Benz company sued this particular company for violation of its trademark. So, as I already said that, and you cannot claim the whole the ownership of trademark of some particular name. So, Benz, everybody knows that it's a auto manufacturer. The Benz cars are world famous. So, the Benz sued this particular Indian company, but the way in which the advertisement is depicted in the picture. So, the Indian court said that yes, this is a violation of trademark of Benz. So, because the way in which the advertisement is put, that is the main reason for held that it was violation of the trademark. So, it is not the case that you can use the names to whatever you want. So, even though the Benz car is nothing to do with the undergarment, but the Indian court prevented the Indian company from using the name Benz, and also the picture, the way in which the picture is put. So, this case also shows that what is exactly what are the criteria for fixing the trademarks. So, trademark, well known mark, certification mark, and also you can give the associations which they grant, and also a certain marks like hallmark, quality, mark, again pointing to the quality. So, there are different categories of marks which can be put under these trademarks. And here you can see that in unlike so you can see the trademark is protected for goods as well as services. So, service mark, it is registered, it is protected. So, it can be emblems. So, and the series of, for example, it cannot be patentable. The emblem of intergovernmental organizations cannot be used as a trademark. The state emblems cannot be used as a trademark. There is prohibitions. So, what can be patented, what cannot be patented, there are specific distinctions. And trademark can be registered, it can be, the term of protection is 10 years, and which can be renewed from time to time. So, all over the WTO countries now it is 10 years protection of trademark. And I already said that all the international conventions are now applicable to the member countries as well, relating to their respective fields. So, here we can see that the trademark, the Paris Convention is already a part of the TRIPS agreement. So, the trademark provisions and patent provisions are applicable. So, it is very clear. See, in some of the countries it is 10 years which is provided in India, and some of the countries it is in TRIPS agreement it is specified. So, some countries go with the TRIPS agreement protection, and some countries go with more than TRIPS agreement protection. And patent, as I told you, that the patent criteria is mentioned, what can be patented, what cannot be patented is mentioned, and also the basic standard of protection and the minimum the minimum term of protection is also mentioned under the TRIPS agreement. So, and if we can conclude that the basic protections are available and the countries are implemented these provisions according to the TRIPS agreement, even though for countries like India it took some period of time to implement, but it is implemented. So, in the next classes we will see the individual respective the category of intellectual property rights, other categories of intellectual property rights in the coming classes. Thank you.